Okay, good afternoon. For those who don't know me, I'm François Tanguy-Renaud. I'm the director of the Jack and May Nathanson Center on Transnational Human Rights, Crime, and Security here at Osgoode, which is the proud host today of Tarunab Khaitan, Professor Tarunab Khaitan. I say we're proud to be hosting this talk because, as many of you may know, Tarunab is one of the world's leading authority on discrimination law. He's currently the Hackney Fellow in Law at Wadham College in Oxford, as well as an associate of the Oxford Human Rights Hub. But really, Tarunab and I go back a long way. We were both at Oxford as Rhodes Scholars together during our graduate school days, and we've been friends ever since. So it's really thrilling to have him here today. In fact, one of Tarunab's claim to fame, if I might put it like this, is that he was my first Hindi teacher. Now, I say that it's his claim to fame not because I speak Hindi. In fact, it was an utter failure. I only speak really basic street-level Hindi. But because of the patience and resilience that he showed in the process, which is a testament to the kind of scholar that I think Tarunab is. So to be sure, Tarunab completed his undergraduate degrees, BA, LLB, at India's premier law school, the National Law School in Bangalore. And he then went on to Oxford to complete his postgraduate studies. He received a BCL with distinction, an MPhil with distinction, and again a prize, DPhil, at Exeter College. And he was then appointed as Pennington's student at law, which is a prestigious postdoctoral position of sorts, before being appointed to Wadham permanently. Now, despite his, I can say that, fairly young age, Tarunab's work has already had much impact. So for example, his, and I think that's actually accurate, his comparative research had a significant impact on the seminal Nas Foundation decision of the Delhi High Court, which decriminalized for the space of a moment homosexuality in the National Capital Region of India. And when the Supreme Court of India mindlessly decided to reverse this decision and to recriminalize homosexuality, well, Tarunab was one of the first ones to lead the charge publicly, pointedly criticizing the decision, for example, in the context of a modern law review commentary. He's also been working recently, he was just telling me, with the government of Delhi. If you follow Indian politics, you know that there's been quite a groundbreaking election of a non-aligned party, the Common Man Party, the Aam Aadmi Party, and there's a lot of hope that things might turn around. And so Tarunab has been working with them to come up with a new anti-discrimination bill. So a very public scholar, as it were, even though he's going to talk to us today about the public-private divide in discrimination law. Tarunab has extensively written in discrimination law. He also writes on dignity, social rights adjudication, as well as constitutional law, administrative law, and human rights more generally. His most recent book, which is on display here, Oxford University Press, please note, A Theory of Discrimination Law. I think it's no surprise that it's gotten really, although it was published earlier this year, already a lot of attention. There have been book symposia in England, in Chicago, yesterday at the University of Toronto. So we're really pleased, really, to have Tarunab with us today, speaking to us to part of this ambitious project. His talk today, as I said, is entitled The Public-Private Divide in Discrimination Law, a topic which I think many of you will find to be of significant interest. So without further ado, please join me in welcoming Professor Tarunab Khaitan. Thank you very much.
François, thank you for that very kind and generous introduction. It's a great pleasure to be here at Osgoode, and I believe that you've all given up the pleasure of at least 3 other competing and no doubt very exciting talks to be here. So I'm especially grateful to you for turning up. Now, my publisher wants the book to be displayed at every talk I give. So if you like the cover, please judge it by the cover. If you don't like it, then you might want to listen to what I have to say. So. Maybe I should give a quick overview of the argument of the book before focusing on the precise chapter that is the subject of the talk today. So the book tries to to present an ambitious, overarching theory of discrimination law. And the analysis is structured around thinking about discrimination law at two different levels. At a broader, higher systemic level, where the right question to ask is what is the point and purpose of discrimination law, and whether this point and purpose is justified. And at a second, intermediate, distributive, more hands-on, nuts and bolts level, about the rights, duties, and their distribution in discrimination law. So the chapter I'm going to present to you is from this second part of the book. But I just want to say a few things about why this two-structure analysis, why I found it helpful. So the idea is borrowed from a seminal article written by Joan Rawls in the 50s, which some of you may be familiar with, called Two Concepts of Rules, which was then borrowed by Herbert Hart to explain the theory of punishment. And both of them were intervening in these theoretical camps, trying to understand whether the point of criminal law was deterrence or desert proportionality-based arguments. And they both explained that the point of the system of punishment, the overarching systemic purpose, is punishment. But once you have a system of punishment, how we ought to design and distribute punishments, who should be punished, how much should they be punished, is to be determined based on a different principle, a fairness-based principle of desert and proportionality. And to my mind, I thought that sort of distinction made sense of a lot of debates that were going on in discrimination law. So at the systemic level, I make two broad claims, and I will shut up about the overview once I've told you what those claims are and move to the specific. So the two broad claims I make at this higher level are, first is a conceptual claim, and I think the character of this claim as a conceptual claim is important because it has previously been made as a normative claim, but I say this is answering an is question, not an ought question. And the conceptual claim is that the overall systemic purpose of discrimination law is to reduce and ultimately remove substantial, pervasive, and persistent advantage gaps between certain socially salient groups. So the idea has been around, and it's obviously in the debate I'm taking issue with people who argue that the wrong of discrimination is somehow individualistic, or it's a procedure sanitizing method which takes out irrelevant decision making from the procedure. I'm taking issue with that and arguing that at a systemic level, if you take the practice of discrimination law in the 5 liberal democratic jurisdictions that I look at, it's undeniable to my mind that the law is about removing certain egregious types of relative group disadvantage. The second related but normative part of the systemic claim is that reducing and eliminating this type of group disadvantage, this type of relative group disadvantage, is essential for a liberal state. So it's a normative argument that grounds discrimination law in the ideal of liberty rather than equality. Anyway, so that's sort of part one of the book. And I'm not going to defend these claims now, but if you have questions, I'll be happy to address them. In part two of the book, and I hope all of you have handouts with you, but does anyone not have a handout? I can pass one on. There's one here. There you go. So here, this is the nuts and bolts part of the law, which, like most areas of the law, the normative structure of discrimination law involves, if you look at the top half of your handout, the right bearers in discrimination law, and here we ask ourselves who can bring discrimination claims and who are the target beneficiaries of the law. And here we think about the protected grounds in discrimination law, like race, sex, religion, etc., and various groups. I do have a distinction between rights bearers and the protectorate of discrimination law. I do think they're different because even though men, for example, can bring anti-discrimination challenges and therefore are rights bearers in the law, they're not the protectorate that discrimination law is primarily interested in, and I have an argument about why this distinction makes sense in a different chapter. The second part of this normative structure is what the rights and duties are. And as you will no doubt be familiar with, from its origins in a very intentioned, prejudice-seeking, direct discrimination prohibition in various contexts, discrimination law has expanded to come up with new tools like indirect discrimination, prohibition, ground-based harassment, reasonable adjustments, affirmative action, etc. And that account needs to be made sense of, and whether these tools are coherent, do they make sense together, are they disparate, etc. So that's chapter 6 of my book. The third leg, which is the subject of today's talk, and this is largely chapter 7 of my book, is who the duty bearers are in discrimination law. And this is a question that, to my mind at least, has received very little attention. But I think what the law here has done is quite unusual if you look at it carefully and see what's really going on in discrimination law, and one that demands a theoretical account. So that's what we are looking at. So who are the duty bearers in discrimination law? Now, historically, in the United States at least, the duty of non-discrimination starts with the state, and that's been the story in multiple jurisdictions. Not the United Kingdom. The United Kingdom is an exception to this historical trend where there's been an ancient common law duty. I don't know if it's not much talked about today. It was the duty on common callers to serve whoever was able to pay. So certain public professions were deemed to be common callings. These would include innkeepers, common carriers, common laborers, and common prostitutes, as well, things that we rightly wouldn't call, wouldn't include. But the idea was that if you were able to pay and were reasonable, not making a ruckus in your hotel room, an innkeeper could not refuse to lodge you, etc. Now, it is a forebear of modern discrimination law. It's also quite different because it wasn't ground-based. You didn't need to show that you were refused accommodation because you were black or a woman or Jewish, etc. If all you need to show was I was willing to pay, and they wouldn't let me. It was of course used primarily by black people and Jews in the early half of the 20th century in the US and in England to bring what we would understand as anti-discrimination challenges before the statutes came around. But there you can already see anti-discrimination type regulation of bodies that we would think of as private. Anyway, but even in other jurisdictions, the expansion from the state to other more private groups has happened everywhere, or at least in all the 5 jurisdictions that I've looked at. And these jurisdictions are the United States, Canada, South Africa, the UK, and India. So they typically include, apart from the state, employers, landlords, service providers, and retailers. Now, there are 4 characteristic features, I think, which this group of duty bearers share, and I think they're quite interesting features. So I think the first, and this is the bottom left half of your handout. The first of these features is what I've labeled non-universality. Now, compare an anti-discrimination norm with a tort norm like negligence. Right? Now, we all share the burden of negligence law, right? We all have a duty to not act negligently. I cannot, spill this water which will injure you in some way, etc. Right? But the anti-discrimination norm does not work in that manner. It's not a universal duty. Not all of us share it. It's defined, or its incidence is on particular select people in select contexts. The second feature is non-reflexivity, which is if you agree with my first systemic claim that the point of discrimination law is to reduce relative group disadvantage, it, at least at first glance, might make sense to make the duty bearers members of the more advantaged groups. Right? But that's not the choice that the law makes either. So an employer bears the burden of anti-discrimination whether they are white or black, male or female. So when it comes to duty bearers, discrimination law is just not interested in your group membership. It's interested in your group membership only when you are the rights claimant. But all duty bearers are covered. So there is no reflexivity between the right bearers and the duty bearers. The third feature, I believe, is professionalism. That all these duty bearers are in some way professionals. They all wear a professional hat and they carry the burden of anti-discrimination only when they act in their professional capacity. So an employer is still free to discriminate when she throws a birthday party and refuses to invite her Muslim friends. Right? That's not a concern, well, unless it is work-related, unless it's a workplace party, etc. Right? So only when she has her employer hat on does the law become interested. The state as a state is a bit curious in this regard because the state, I think, always acts qua state, but because the state must act through human agents who wear two hats, officials of the state but also private citizens, we have conflict cases, and there must be similar cases in Canada. I'm thinking of cases like Hobby Lobby, cases where their private citizenship rights, like freedom of religion, typically is in conflict with their duties under discrimination law to not discriminate on grounds of usually sex or sexual orientation. And the final feature that I think the duty bearers in discrimination law possess is unidirectionality, which is that the duties are imposed on employers but not employees, unless they're acting as agents of the employer. They're imposed on landlords, not tenants. So the tenant can still choose not to seek housing from a black landlord. They're imposed on retailers but not consumers, and so on. So once we notice these features, I think there's something unusual that the law has, that the law is doing, and it's not something that immediately makes sense. So what's going on here? I think that the way we can explain what's going on here is by identifying two normative foundations of which justify the choices that the law has made in selecting these duty bearers. I have a postscript to the story because, as Francois mentioned, since writing the book, I've been working on an anti-discrimination bill in the context of the government for the government of Delhi, and that has forced me to rethink quite a few of these features, because in anti-discrimination law in an Indian context, where a lot of discrimination is quite private and does not satisfy these features necessarily, like the local community organizing itself to stop a couple from marrying each other because they belong to different communities. That was challenging, and I had to think about how to make sense of this. But I think once you look at the normative features that explain these current factors, that becomes more sensible. Anyway, so I say in Chapter 7 that the two broad reasons why the choice that the law makes is the right one. Right? And I'm not talking about gray zones or hard cases. Of course, there will be difficulty there. But the first of them is publicness. And I don't think that discrimination law has abandoned the public-private divide. I think it is still true to the broad liberal assumption that private persons are free to do what they like unless there are good reasons to stop them from doing so. And the state must not do anything unless it has very good reasons to do it. But what it has done, I believe, is adopt a more nuanced and realistic approach to the public-private divide, primarily by challenging the notion that public bodies and private bodies are somehow two discrete boxes, and instead recognize that they lie on a spectrum of varying degrees of publicness. And you can see this feature articulated in different jurisdictions in different ways. So some jurisdictions understand or impose anti-discrimination duties only on employees of a certain size, which have a certain amount of number of workers, or have a certain type of turnover. And I believe what's going on is a recognition that the bigger you are, the more public you become as an employer. So not only is the divide put on a spectrum, but there's also, it seems to me, a recognition that there are multiple factors that are being used to determine whether you're public or private. And the state, obviously, is a paradigm case of publicness, occupying one extreme end of this public-private spectrum, I think is explained by its radical other regardingness, which is that the state, at least normatively, is essentially and I'm worried about making this claim here, especially with Francois sitting there. I don't know how he'll react to it. I think it's essentially a means to securing other goals, especially the well-being of its subjects rather than in itself. And other bodies we can expect similar other regardingness from include charities or public contractors who have contractual other regarding duties. But publicness could also result from other factors, and what may seem at first glance to be the opposite of other regardingness, which is monetization. I think monetization of transactional relationships grants a modicum of publicness to certain groups, because like other regardingness, it depersonalizes that relationship. And this is the familiar feminist understanding of the regulation of the state and the market, but the family is still left out. And I think it was the family which was my challenge with the Delhi Bill. But and I think the third point, which is important and which I think speaks to the feminist critique, which is that publicness is also a factor of power. And I think that the feature of unidirectionality in particular is a recognition that the more powerful, typically the more powerful person in that relationship is the one who bears the duties, so employers but not employees, etc. And that also means that these are contingent judgments. So, in a big supermarket, as a consumer of milk from farmers, may well be a situation where the duty ought to be reversed, where the consumer should bear an anti-discrimination duty because, in this case, they would be a lot more powerful than the retailer. Finally, publicness can be assumed if you, and this was the rationale used in the ancient common law doctrine of common calling, which is if I open up shop to serve the public, I can't then pick and choose who I can serve. Right. So that was one part of this paradigm, trying to make sense of these features of discrimination law by understanding publicness. And as you would appreciate, this is one chapter in a book whose goals are largely incidental. So I don't interrogate quite deeply about the normative justification of these publicness features, but they seem to me to be intuitively correct. The second and overlapping rationale was that the law imposes anti-discrimination duties on people who are gatekeepers of basic opportunities in our society, opportunities that the law is seeking to distribute, opportunities like employment and healthcare and education and access to goods and services and housing, etc. And again, I'm not going to develop that, but I hope that is a fairly intuitive idea. Now, so what are the implications of what's going on here? I think, well, there are some implications within discrimination law and perhaps for other areas of law as well, which also I think grapple with the question of the public-private divide in a liberal state. I think the main implication is that it explains the conflict cases reasonably well. So, and I've already alluded to this, the conflict between religion and sexual orientation, for example. So taken, or would most people be familiar with the Hobby Lobby case here, right? Okay. So in Hobby Lobby, an employer, and it wasn't quite a discrimination law case, although the dissent does talk about the sex discrimination implications of the employer's refusal to provide certain types of contraception within the health insurance. So that was the main question in the case, and the employer claimed religious freedom as a ground for being exempt from the public duty to provide contraception to female employees. The majority of the U.S. Supreme Court, I think, sadly but unsurprisingly, agreed with the employer's claim and did grant that freedom, right? But I think what's important in understanding the nature of that claim is this: the employer, within a framework of discrimination law, would be a duty bearer but not a rights holder, because these are mutually exclusive categories in discrimination law. Right? So the religious exemption claim that the employer is making is a religious exemption claim that seeks to be exempted from the duties in discrimination law, but not an exemption claim within discrimination law, which would be, for example, a religious accommodation claim that I think Canadian jurisprudence is quite familiar with. So I belong to a religion which has a different festival calendar from the mainstream religion, and the employer's duty then to accommodate my claim by allowing some flexibility in holidays. Now that is a type of claim which is premised on religious discrimination. An employer's failure to accommodate that would be discriminating against me on the grounds of religion, whereas the Hobby Lobby type of case is an opt-out from discrimination law rather than a claim within discrimination law. So one explanation I think this account gives is to separate the two very different types of religious accommodation claims. And I'm not necessarily suggesting that one is more legitimate than the other, but I think there are different types of claims, and we ought to be clear that these are different types of claims. The other implication I already mentioned, which is that if publicness is sensitive to power, then we need to be open to the possibility that these power relations may be reversed. But let me speak in maybe a couple of minutes about the Delhi Bill, which, well, I shouldn't call it the Delhi Bill because the government hasn't officially adopted it yet.
It's the Karuna Bill.
It's the Khaitan Bill. That's right. Yeah. So the trouble was that these models, which have largely emerged in the context of Western liberal societies, but also in South Africa, did not address a fundamental problem of discrimination in Indian society, which is endogamy. The entire system of caste discrimination is premised on the careful regulation of who can marry whom. Right? And that is, as you would expect, spilled over to religion, right? And these structures of caste and religious discrimination are to a great extent sustained by this idea of endogamy and with very heavy social policing of who can marry whom, right? And that story just does not fit within this framework, because it's the sort of thing that one would instinctively think liberal states should just stay out of, because the people enforcing these norms are often family members. They're not professionals. They don't necessarily have these characteristic features that I identify. Their community leaders or whatever. But what they do have, what they do satisfy is the normative basis on which these features are organized. Right? They have enormous social power. They are gatekeepers of certain types of opportunities of choosing who your partner is, and so it helped me make sense of why regulating this type of social policing was quite appropriate for a liberal state to do, so long as the regulation is to protect and enhance choice rather than to restrict it, right? Choice of the consenting adults. So I think that the law has taken some lessons from the feminist slogan, the personal is political, not fully explored, and I think the Delhi example shows that there are further possibilities. There's more the law can do without giving up on its fundamental premises about the public and the private. I'll end on one final point, which is that the law's decision to regulate or to not regulate does not seem to turn on the moral badness of the discrimination entailed. I think that if I decide that I'm not going to have Jewish friends or Muslim friends, it makes me a terrible person. But that's typically been outside the law's remit. So that's sort of I think an obvious but an important point that discrimination law does not, at least in its regulation of duty bearers, does not track a morality gradient. It is doing something else, and I think it is tracking power and publicness. So I think I'll stop there, and I'm happy to address any questions you might have. Thank you.
So we do have plenty of time for questions. There are some microphones at the back which I think will be circulating. Just make sure no. Okay, so this microphone will be circulating. Just make sure you have the microphone before you speak. So anyone, Professor Ryder.
Thanks so much. Really appreciate you being here and looking forward to reading the book. It sounds fabulous. I guess my question is, you've been talking about an overarching theory of anti-discrimination law as if it's unified. And could we make the argument that in fact there are different bodies of anti-discrimination law that perform different functions and may situate in different ways as a result on the public-private divide? When I think of, for example, in Canada, the differences between the prohibition on discrimination in the Constitution and the Charter of Rights operates on the basis of a fairly strict and rigid conception of what counts as government and to whom it applies. And then our human rights legislation makes no distinction between public and private in that sense, although it does have a public kind of conception along the lines that you've described so well. And then you can think, of course, of anti-discrimination norms in various local contexts and policies, practices that we may not be used to calling law, but are functioning in a very legal way, but in a more private context, perhaps, at least in the way some people think about private. So I wonder about that overarching project, whether it really makes sense to talk about discrimination law as a unified body of study, or whether there might not be some advantages to looking at it as operating in different ways in different contexts, including different conceptions of the public and private.
Thank you. That's an excellent question, and it took me a year and a half to come to grips with it. So I think the question you're asking is fundamentally a methodological question that goes to the heart of doing any particular jurisprudence, which is not jurisprudence of the law generally, but jurisprudence about an area of law. And at heart, it's a question about, is it even possible to do that? What is your data set? Do you look at one jurisdiction or multiple? How do you explain differences between jurisdictions? So is theory, and one could ask the same question for, is a theory of tort law possible? Is a theory of criminal law possible, right? The way I have tried, and the first half of the book is geared towards defending the methodology that I adopt. So the book is quite conscious of that problem. And what I've done is a two scale. So the response, the first part one of the book is defining the scope of what my data set is. So what is the phenomenon that I call discrimination law and that I'm going to defend? And that in large part is a response to an American academic called George Rutherglen, who I don't know if you're familiar with an edited collection that Debbie Hellman and Sophia Moreau published called Philosophical Foundations of Discrimination Law, where he had a chapter, and I have a reply to his chapter, where he basically said, look, what's going on in discrimination law in the United States is so messy, so diverse, so these are just different tools that we willy-nilly have ended up putting in the same basket, and there's no coherence and organizing principle to that. So chapter 2 of the book engages directly with that claim to identify identity and coherence granting features in anti-discrimination norms in these 5 jurisdictions, and they as necessarily are presented at a level of abstraction and thinness. But I argue in chapter 2 that every norm that we would call an anti-discrimination norm would necessarily satisfy these 4 conditions. And any norm that does satisfy these 4 conditions would be an anti-discrimination norm. And I call the chapter The Essence of Discrimination Law. And the second and the third chapter is what I call the architecture of discrimination law, which looks at structural features in the law. So and I am coming to a response to your question, which is this: the way I think theorizing particular area of law is possible is by being more modest about theoretical ambition and possibility, which is that one cannot give a theoretical account of the lowest level at which the law operates, because that would necessarily be different in different places. But I think, and that's what I've tried to do in the book, at the top level and at the intermediate level of inquiry, some general claims can be made about the law, and I believe they are illuminating. So that's what I've done.
I just want to pick up on Professor Ryder's question. So I like the way in which you disaggregate the public, right? Saying the state is, by definition, public, it's other regarding, and I won't dispute that it's primarily instrumentally valuable. I think that thinking the state as inherently valuable opens the door to all kinds of scary arguments that I don't want to contend with, so we don't disagree here. But so the state, and then you say the market, monetization, depersonalized, that's also public, and then the more feminist kind of critique, personal as political, who has power, that's also public. And you say, well, discrimination involves this idea of publicness. Now, I wonder if you think that this kind of way of unifying the theory through that one feature puts pressure on what Professor Ryder is mentioning, the constitutional discourse about discrimination, because you haven't spoken so much about constitutions, right? You've spoken about discrimination laws. But a number of jurisdictions, South Africa is one, India, to the extent that we follow the NAS Foundation High Court judgment, recognize a kind of horizontal effect, right, of anti-discrimination provision to say between private parties might also apply, right? And so I'm wondering whether your analysis, in terms of these specific kinds of jurisdictions that do recognize horizontal effect, puts pressure on basically saying, let's rope into the Constitution all of this kind of anti-discrimination baggage, right? Because it's unified, right? So if really we're going to recognize horizontal effect, state action is not the requirement for talking about discrimination in constitutional terms. Why shouldn't it all be done there as opposed to us bothering with statutes? It might be practically more easier to do so through statutes than to ask the courts. It may not be, the best to do this, but isn't this a kind of entryway, or isn't that the logical conclusion of the kind of argument that you're making?
So you're quite right that, well, insofar as the state is governed by constitutional provisions, I think that's quite compatible with what I've said.
Sure.
Because
but horizontal effect goes beyond this, presumably.
No, it does.
Right?
Right? So the state obviously is public all the time and therefore is governed all the time. Right? The trouble with the question about horizontal effect does seem challenging at first glance, but even in South Africa, my understanding is that the fairness analysis that the court conducts in horizontal discrimination, and there hasn't been a big enough test case to fully explore that, takes into account precisely the factors that I identify. So this is not an institutional theory, right? I don't care whether these features, well, I don't care in this book, but whether these features become articulated by legislatures or by courts, but it seems that even when there is horizontal effect, courts are not treating non-state bodies in the same way as they're treating the state. And when and how regulation of non-state bodies ought to happen seems to be informed by these types of features of publicness and power and even in British cases where you have the indirect horizontal effect of the Human Rights Act, where the Human Rights Act does not give rise to a cause of action, but it can be used to interpret common law and or even statutory law. And again, there, so in Gaidan, for example, the same-sex couple was given access to rent laws. So I think the considerations are the same, even if the way the provision is formulated in constitutional documents appears to be overbroad. So there are two ways of doing this. Either you define the application scope to begin with, or you have an overbroad definition, but then do all the work at the justification stage. And I think what's happening in constitutional horizontal jurisprudence is all of this is happening at the second justification stage. But it's there.
There's a reason for keeping these things apart, right? Because your analysis made me think that you would want, for example, to see everything treated at the constitutional level. At least it'd be a possibility that you'd be willing to countenance, right?
It's a pragmatic institutional choice, and I think it's for a whole host of institutional reasons, not making the legal system too top heavy, etc. There are good reasons why private relation or non-state relations should be governed by statute primarily.
Yes. So.
Thank you for your presentation. I enjoyed it a lot. I was wondering, thinking of power as an element of publicness, how feasible do you think it is to think that a power reverse situation would actually influence or would be rather recognized and make a difference in the context of the established categories of barriers and beneficiaries? So otherwise said, because it just seems to me that when we would have a power reverse, and probably the situations won't be very common, it would be more like a case-by-case situation. How it seems to me that such a situation would actually disturb the model and the characteristics quite a bit. So I'm wondering if such a disturbance would allow for the recognition of the power reverse, and if it would actually change something in the way we think of the barriers.
Forgive me for giving you another institutional response to that very good question, and it's a response that I think every theoretical account has to grapple with, because unlike theorists, legislators and judges have to make all things considered judgments in the real world, right? And therefore, this modesty in theorizing is an essential feature of theorizing. But the response is this, right? There's a tension between what we might think of as justice and fairness, finding exactly the right outcome in every case, and legality concerns about what is the trend in a jurisdiction, who are the people that are most likely to get in, what will be the litigation cost, what will be the information cost, how disruptive. So my response would be a pragmatic one, that if we have a situation where these categories that the law has chosen, employees not employees, landlords not tenants, retailers not consumers, if these categories are broadly correct in identifying where power lies in society, and some people fall through the cracks, that may well be a legality price that is justified. Right? It's a contingent judgment depending on the context of that particular society. That said, I think certain types of private bodies, especially I'm thinking of large multinational companies, may well be so powerful in everything they do that some sort of comprehensive state type coverage of their activities may well be justified, right? And that's a direction that I think is justified by the contingent facts of a place. But I don't think that some people who should have been protected but aren't by the law for legality reasons, I don't think that puts pressures, not on my theory. I think, a theory cannot try to make sense of everything.
Thank you.
Professor Baba.
Thanks. You were making a point of making a distinction between where discrimination law covers something and where it excludes or is excluded from. Unfortunately, I missed everything you said up to that point, so I may just be asking a question for clarification. But I want to ask you about your theory in relation to exclusions and in particular group rights. Because I think it seems to me you can think about an exclusion in one of two ways, either as a discrimination law free space, something that's carved out and away from the law, or you can think of it as a discrimination law created space, that is a space that is within the umbrella of the law's protection, and that the very reason for carving that space out is to promote some sort of anti-discrimination value. And I wonder, when you think about which construction to use within your theory, whether there's any place for thinking about the question of group rights and the dilemma of intra-group discrimination, and what the public law or the statute at play should or can do in respect of those issues.
Can I ask a clarificatory question to your question?
Sure.
Is that question in the context of religion?
Probably mostly so, but you could imagine analogies to other grounds. You could think of, well, we've had issues around, say, black-focused high schools within the public school system, and questions around the legitimacy of that, questions around discrimination within such an institution. But mostly we think about these things in terms of religions, and maybe in the Indian context, the idea of the preservation of culture and tradition, such as the caste system, as the right of a community or of a group to maintain that. Is there any space within your public theory of discrimination law that recognizes that? We see it in South Africa, for example, with the preservation of polygamy under cultural rights.
Yeah, thank you. It's not a question that I addressed in this talk. There are things I say in the book which have implications for it. So let me go back to my broader systemic claim in the book, which is that the point and purpose of discrimination law is to reduce and ultimately remove certain types of egregious, pervasive, and persistent advantage gaps between socially salient groups. Now, that was a conceptual claim, and the normative defense, which I just briefly mentioned, but maybe I can sketch out a little bit more today now, is that I think what egregious relative group disadvantage does is that it denies secured access to three basic goods to members of these disadvantaged groups. And these basic goods, which are, to my mind, essential for a flourishing life and therefore essential for a liberal state to seek to secure. And these basic goods are a secured negative freedom from unjustified interference, secured access to a range of valuable opportunities, and secured self-respect. And the normative argument is, the factual premise of the normative argument is that if you belong to one of the disadvantaged groups, women, black people, etc., even if, so either you're likely to lack access to these basic goods, or your access to these goods is likely to be precarious because of the operation of social power, right? So the security dimension is quite important to my framework. Now, as I suppose it should be clear by now, my interest in relative group disadvantage is for the sake of individual members. And I think that is what ultimately, so yes, discrimination law is primarily obsessed with group disadvantage, but it is so obsessed because of the well-being of individual members. Does that have implication for how we deal with groups? I think it does, to the extent that self-respect is an important component of our well-being, and that voluntary group membership is often an important means of acquiring and preserving one's self-respect. Group autonomy is an important good that the state should respect. Does that also then require exit guarantees from the group? I think necessarily so. Members who want to leave the group must be free to do so. But so this is not a group rights theory, but certain types of group autonomy claims, especially freedom of religion, do come into conflict with discrimination law. And I think that's the point when you walked in, when I was trying to explain that. So what I was reacting against there was a British tabloid explanation of these cases. And you often see headlines, religion versus sexual orientation. And the suggestion that discrimination law is somehow hierarchizing these grounds, that it's putting sexual orientation above religion in some of the British cases. And I was, it might be helpful to sketch out the case and explain what's going on. So there's a case recently where, in England, where a Christian hotel keeper refused to give a double bedroom to a gay couple. The gay couple goes to court, claiming sexual orientation discrimination. The court says, yeah, you have been discriminated, and unanimously finds in their favor. The court was split on whether it was direct or indirect, because the policy was unmarried people, and at that time gay people could have civil partnership but not marriage. And anyway, the majority thought it was direct sexual orientation discrimination. Right? Now, Lady Hale, writing for the majority in the court, repeats at least 2 times that this is not a religion versus sexual orientation case. That if it was the gay couple running the hotel who had refused a room to the Catholic couple because they're Catholics, we would have exactly the same finding, which is you can't do it. And I think that's the point I was trying to drive home, that when rights bearers make religious accommodation claims in discrimination law, that claim is of a completely different character from religious accommodation claims made by duty bearers. Yeah.
My question relates more to what if the hotel keepers were operating a hotel that advertised itself, held itself out, and governed itself as a Christian hostel, and put forward its face as essentially choosing to service members of that community. How would your theory's analysis change in handling those facts in that situation?
I don't think a general theoretical answer is possible to that question. What theory can tell you is what's on the table. I think what's on the table is a religious freedom interest, which the court recognizes in the British case I explained as well. It's called Bull and Hole. So the court doesn't say that they don't have any interest, and there is a judicial balancing, weighing, proportionality analysis that goes on, and the question would be, what is the anti-discrimination interest of the consumers as against the religious freedom interest of the hotel keepers? Sometimes I think if it was a church seeking to employ a priest, the religious freedom interest would be a lot stronger than if they're providing a service which is essentially not religious, which is secular in nature. So I think, what I'm saying is one would need a theory of religious freedom as well, and some way to assess which religious freedom interests are stronger, which are weaker, and how they compare with anti-discrimination interests in that case. So it would be, to my mind, a contingent case-specific analysis which can give an answer.
Can I just ask for one final clarification on your choice of language? I'm sorry to be pedantic. We'll get that on the record. What you're calling the religious freedom interest could also be called a religious equality interest. Are you, and could also be identified as an anti-discrimination interest, being part of a religious equality interest. So what is it in characterizing it as a religious freedom interest? I know you said that a theory needs to be developed, and that's not your project, but it seems to me that you are excluding it from your theory of the anti-discrimination interests at play.
Yeah, you're quite right in that. So the words I didn't use were religious equality. Anyway, right? And part of the project is to explain discrimination law on liberal rather than egalitarian grounds. Because of the structure of discrimination law and the duties that it imposes on certain types of persons and relationships, and doesn't impose on others. So, this is the unidirectionality feature in discrimination law. Duty bearers in discrimination law do not have, within the internal logic of the law, do not have an anti-discrimination interest as duty bearers. So an anti-discrimination interest inheres only in people like consumers and employees and citizens and tenants. It does not inhere in the duty bearers, and that's why I was refusing to call it an anti-discrimination interest. There is quite legitimately an interest in freedom of religion, which we all have as citizens. So that's not an interest that's cabined to and restricted to certain specified groups. But so that was a feature of discrimination law that I was trying to highlight, that structurally it's not a universal interest. We have to cross a threshold. We have to enter a door before we can access it, make claims to it. And hotel keepers simply don't have that claim, but hotel consumers do.
Professor Nadler.
So you just said, I think, that your interest in reducing advantage gaps between groups, your interest in groups is actually interest in the members of the groups. And so, that makes me wonder, so can we recharacterize the point of discrimination law as reducing advantage gaps between, all human beings? Like, can we just take what's lost if we take out the reference to groups, if what we're really interested in is the members of groups? And then I also want to ask, and do these people have to be members of systemically disadvantaged groups? Is that what's important? Or can we take that out too and just say, we want to give freedom, opportunity, and self-respect to all human beings, and that's the point of discrimination law. So what is this fixation on groups? Like, why do we talk about that? And what is the significance of the systemic disadvantage?
Yeah, so thank you. That's a great question. And again, it's a question that, no, I'm not going to give an institutional response to that. I'm going to give a conceptual and normative response to that. So there are many So we can agree, let's say for the sake of argument, that individual well-being is important, and let's also agree that that there is some set of basic goods that is a prerequisite for living a good life, right? And we may disagree on what those are, but let's assume that we can make some headway there, right? Now there are many ways in which we may be denied access to those basic goods. I think poverty is paradigmatically, almost definitionally, the absence of access to these basic goods. Several types of criminal behavior disrupts your access, especially if you think that negative freedom is part of that basket of basic goods. Certain types of torts deny you certain basic goods. Right? So, in providing a theory of discrimination law, my attempt was to show that membership of relatively disadvantaged groups also disrupts your access in a unique way which demands a unique legal response. So I don't think that relative individual disadvantage without the intervention of groups is necessarily a problem for basic goods access. Right? Absolute individual disadvantage is, right? But and so this is a sufficientarian account, right? With Harry Frankfurt, that what we need is a sufficient level of basic goods to lead a good life. Differences between individuals above that threshold don't necessarily have a problem with basic goods. But I think when these differences take a group dimension, then the access of individual members, even of the rich black man example is often given, even their access becomes precarious and therefore contingent. So what the group dimension does is allows a theory of sufficiency to take relative disadvantage seriously and not just absolute disadvantage. So traditionally, people said that absolute disadvantage is a liberal concern, relative disadvantage is an egalitarian concern. What I've tried to show is that when relative disadvantage maps onto group disadvantage, then it should be a liberal concern as well, because it has implications for absolute advantage of particular members. Does that make sense? I don't know if I've been coherent.
Yeah, no, that makes sense to me, but so I just wonder, so if I want to make a claim of discrimination, is it going to be important that I show that I am a member of a group? So can a lone religion, I have a religion unto myself and I'm being discriminated against. Does that matter that I can't show that I'm part of a group? Or could Christians who were probably not systemically disadvantaged, could they bring a claim that they're being discriminated against? That's what I...
Okay, that's a good question, and it's again answered in a different part of the book in chapter 6. But if you look at the handout, I distinguish between right bearers and the protectorate, right? And that question speaks precisely to that distinction. Right? Now, discrimination law responds to that problem in a funny sort of way. Certain types of characteristics, like pregnancy, disability in particular, are protected entirely asymmetrically, which is an able-bodied person, a non-disabled person cannot bring a disability-based challenge or at least in several parts of the law. A non-pregnant person, especially, cannot do so either. Right? On other grounds, I've described the protection as largely symmetric, which is that prohibitions on direct discrimination and indirect discrimination are symmetric. Men and women can bring a claim, all religious groups can bring a claim. But there are strong affirmative action exceptions, but affirmative action only in favor of the disadvantaged group. So you can't have affirmative action to favor men, for example. Right? And the way I explain that in chapter 6 is through the expressive salience of certain characteristics. So when certain characteristics become expressively salient, they they come to inhere so much meaning and identity and importance for members. You cannot deal with the relative disadvantage of the disadvantaged groups without dealing with the salience question as a whole. And it's in part a pragmatic response because asymmetry on grounds which are expressively salient is likely to be counterproductive, is likely often to increase the disadvantage of the group, is more likely to invite backlash. It's and for a whole host of expressive concerns, the law allows men and religious majorities and racial minorities, but not the non-disabled and the not pregnant, to bring anti-discrimination challenges. But that does not disturb the essential claim that men are protected because women are disadvantaged. If sex was like, I don't know, eye color or the first letter of your name, things that don't divide our communities along disadvantaged lines, then there would be no reason to protect men or women. Right? So the fact that one group within that expressively salient characteristic is disadvantaged is essential for discrimination law to take notice of the ground itself.
Professor Bhatia.
Thank you for the talk, and I apologize if this question relates to another part of the book, not having read it, but I was wondering a little bit about the characteristic features and non-universality, non-reflexivity, professionalism, and unidirectionality, because in a way, looking at them, and I think it partly, Professor Ryder mentioned it briefly, when you're looking at, sort of the private divide and the soft law and codes and that kind of context, maybe in the employment context, for instance, these features don't necessarily play out. But then it made me think of, so maybe it's a question just to hear more about the soon-to-be Delhi model. So how do these transfer and map onto those settings, or do you have to kind of scrap them?
Yeah, so I think what's essential is the right-hand side of that flowchart. I think the characteristic features have come to embody the publicness and opportunity gatekeeping functions in the laws as they exist, but these are not the only ways of doing it. Right? So I think we can, when the opportunity requires, directly access publicness and power and come up with different models. But that's not a full answer to your question, because you also talked about soft laws, and I'm sorry I didn't respond to it the first time it was asked. I think despite all these constraints, I believe liberal constraints on how far the law can go, and quite rightly the state does not tell me I should not refuse to invite Muslim friends to my birthday party, for example, or have Muslim friends or not, right? I think the law here also performs a norm-setting function, and the idea that it does not track a morality gradient is important, but the law is also performing, I hope, an expressive and perfecting function in this case, where it's quite the right thing for us to think that it's a terrible thing to do, to discriminate on these grounds, even in areas where the law quite rightly does not regulate. So I think voluntary adoption, non-state coerced adoption of anti-discrimination norms in other areas is a good thing and should be welcomed and certainly compatible with my claims.
I have another question about the possible downstream implications of your theory, because you're trying to reconstruct the law as it is, right? But so your claim that discrimination law has to do with, doesn't have to do with wrongs, moral wrongs, right? I think the claim is it doesn't have to do with private wrongs, right? It has to do with something that is wrong, but when carried out in a public way. Is that correct?
Yeah, wrongs do have a place, which I haven't explained yet, but
So I'd like to know a bit more about this, because if indeed, so I seem to say remedy those gaps because those gaps are problematic, right? They're problematic. Some people would say, well, they're problematic because they're wrong. We shouldn't organize our society like this. And then the moral explanation for it might be sufficientarianism could be just one explanation of this.
Yeah.
If you're going to characterize it as wrong, then public wrong, then your theory might have implications for the kind of remedies that are then available. Public wrongs, we tend to think of the quintessential remedies for public wrongs are condemnation and punishment, right? That's not typically how we think of discrimination law, but possibly that might be one way of remedying those wrongs. Just take the guys out of circulation who discriminate, put them in jail, right? So I'm wondering whether that's something that you'd be willing to contemplate, or whether I'm just missing the target, or mischaracterizing it.
No, so Francois, you are not mischaracterizing it, because this is again a dimension I didn't speak to. So let me go back to my two-level Rawlsian distinction between systemic point and purpose of discrimination law and the distributive dimension, right? And as in the Rawlsian and Hardian understanding, you can see that the systemic purpose, they talked of criminal law and contract law, is explained in consequentialist terms, right? And the distributive dimension is explained in some sort of deontological basis, right? I track that sort of divide quite faithfully in the book. So I've already told you what the systemic goal is, reducing relative group disadvantage, which is the broader instrumental purpose of discrimination law. But in chapter 6, I explain law often uses the idea of wrongfulness as a distributive device in tort law and criminal, etc. And discrimination law outside affirmative action is not an exception. So there is, every discriminatory act is wrongful in two ways. It is wrongful in the systemic way of exacerbating relative group disadvantage, but it's also wrongful in an individualized, particular way, in making a person suffer for a morally extraneous characteristic. And that gives it, at the distributive stage, a private law type character. So
Why is that a private law type character?
Well, in the sense that wrongfulness between that private relationship,
right,
or between the relationship between the wrongdoer and, I don't want to use the word victim, but okay, the person aggrieved, is important in discrimination. So you must be able to draw a straight line. So I can't go to court to, suppose you give a big donation to the Tory party, which is one, let's say, can show will lead to systemic exacerbation of group disadvantage, right? But that's not enough in discrimination. I also need to show how you have wronged me, right, by doing something that uses a morally.
So presumably a lot of criminal wrongs are just like that, right? So say if I assault you, I assault you personally, but I also assault a certain kind of idea of social ordering, etc. Right? So it seems to me that could just map onto most criminal wrongs are like this, right? So and so that's why my question about possible remedies. I said, why don't we have the reaction of saying, well, yes, you could ask people to stop doing what they do, but why not go one step further and say, well, that was wrong, right? It was wrong in a public way. It has this systemic dimension, and therefore, let's look at the whole gamut of remedies.
Okay, now I understand the question. Sorry.
Okay.
So the question is, why not? Why is it not criminalized? Why is it treated in?
Right. I mean, you might have an institutional response to this also, but the question is, normatively speaking, I'm not sure that it's that different, given the way in which you frame the nature of the wrong. Right?
Yeah. Well, Francois, I haven't thought too deeply about this, but let me give a response, and then I need to think more about whether the response is institutional or normative. And the response is this: they have, by the way, been anti-discrimination statutes that have been criminal in nature, and in fact, all the two existing anti-discrimination provisions in India are criminal, and I believe the first British bill was also criminal, and I think, don't quote me on this because this is off the record, and I could be wrong about this, but I think it was made civil as a means to make it to kill the bill, or to make it pointless or less intrusive. If the problem with criminal liability is that it would have stopped the expansion of anti-discrimination duties in its track, because criminal law quite rightly comes with duties of strict and narrow interpretation, and the requirement of the standard of wrongdoing has to meet a sufficient threshold. Right? Now, in many jurisdictions, introduction of anti-discrimination statutes gets rid of the most overtly prejudicial, sort of animus-driven acts relatively quickly. In a decade or two, employers and they all wisen up to the law and stop doing it. And even not all of it is strategy, right? Some people believe that they've stopped discriminating, right? And which is why Griggs had to happen, indirect discrimination came about. And what's harder in industrial societies today is to deal with the unconscious, more hidden, more subtle forms of discrimination. I worry that type of discrimination, which is where the action is today in practice, meets the threshold requirement of criminality. And may well never have developed if discrimination law was criminal law.
Because of the mental element.
Because of the mental
Okay.
element. That's right.
Any other questions? Professor Ryder.
Sorry, I don't want to tax your patience too much.
No, please, this is a lot of fun.
Just a quick question about, you characterize rights claimants as not having duties, and rights bearers as being the sole bearers of duties in anti-discrimination law. I wonder about that claim too. Particularly, I don't know, a couple of examples that come to mind are in jurisprudence on family status discrimination related to an employer's obligation to accommodate child care obligations. It's very common for our tribunals anyway to say, has the claimant actually explored all of her other options? Because if she hasn't, then we're not going to put it on the employer. See the same kind of thing in accommodation claims all the time in the context of disability. That is, it's conceptualized as a process that places reciprocal duties on both claimants and, well, on the rights bearers and the bearers of the duties. That is, if you don't disclose the nature of your disability and it's not and the employer shouldn't otherwise reasonably be aware of it, then you don't really have a claim. And there are other aspects of the duty there are various duties imposed on the rights claimant in that process of accommodation, and it's not just a one-way. Those are just a couple of examples off the top of my head, but I wonder if it's accurate to describe this body of law as not being reciprocal in the duties it imposes.
So the duties that you identify, I wouldn't call them anti-discrimination duties. So they may well include duties to act reasonably, duties to not be an idiot, to not bring vexatious claims, to not be to be sincere, etc. But they're not anti-discrimination duties that claims. That does not mean that the story you tell is not problematic for other reasons, because I think what's really, if I had to make sense of that conceptually, I think what's really going on is the courts trying to figure out at the justification stage is making this accommodation demand on the employer justified or reasonable, right? And there costs play a role, and I think quite legitimately costs play a role, but a society has to decide, well, costs are always there. Right? The only question is who bears those costs, right? And and you could think of asking the same question for pregnancy, for example. Well, have you explored other options? Did you have to become pregnant? Could you do it 2 years later? Right? And as a society, we have decided, quite rightly, that that's not a cost the mother needs to ought to bear, but employers should. And when we haven't made those judgments as categorically for disability and for age, and we still pass on some costs to the rights bearers. That's quite right, but I was, when I said they don't have any duties, that was too glib. They don't have duties of anti-discrimination.
Any further questions? Yes, Professor Davis.
I've been having some thoughts, on the characterization of this as being more concerned with groups than individuals, and I just want to share some random thoughts and see what your response to it is. That I've been thinking that the big thing about groups is that they have the potential to organize to greater and lesser degrees. I mean, the isolated oddball, can assert rights against one of the common calling people, but they get very little. The isolated oddball gets very little help from a human rights commission, right? Because of all those reasons. Because people need to organize to get their ground of discrimination included in the statute. But groups organize to differing degrees, right? I mean, some it's basically just a lobbying organization. They collect money and they organize letter writing and set loose the Twitter dogs and that kind of thing. But other groups, and historically this includes religion, have had much greater claims to self-government, right, in terms of regulating the lives of their members. And in Canada, likewise, we have, the First Nations, who are typically wanting to resist claims that they're just another, race group, that it's the self-governing claim that is threatened. And of course, governments, when they're trying to keep a lid on things, which is usually a major input into policy making, they're very concerned with any group that has the potential to organize revolutionary activity, right? And that historically, that's why freedom of religion was such a big deal, much less so now. But groups that have stronger claims to self-governance get in trouble more with that kind of conflicting rights type thing. That's why religious groups have trouble, because they have employees, they run schools, they do things like that. And First Nations in Canada get into trouble when it's residency bylaws and things like that, where they're actually much more involved in governing their own membership than the typical group that only organizes to the extent that they're lobbying government. So can you respond to that range of thoughts in terms of why groups are not all the same?
Well, okay, so let me start by I think re-articulating, hopefully in a better manner, my response to Faisal's question, which is that the anti-discrimination norm is important, fairly weighty, but it's not the only thing we care about. And there are quite a few other things that the state quite rightly does, and sometimes those things will give way to the anti-discrimination norm when they're in conflict. Sometimes it's quite right for the anti-discrimination norm to give way to other weighty values. And the autonomy of certain groups is one of those values when those groups are valuable for their members, right? So that's sort of, as in this is and I'm repeating myself, but I don't think just this theory will tell you how to resolve particular cases. Groups are different, absolutely, you're right that groups, indeed are different, and their differences manifest themselves in very different ways. So I heard part of your question as asking, what if the group is so weak that it does not even have the political muscle to get into the protection box in discrimination law? That is a failure, but it's not a theoretical failure, it's a political failure to my mind, and it's a political failure that we ought to have responses to. And one institutional response in some jurisdictions has been to allow courts to expand the box. Canada is one example where one individual can go to court and say, look, my group doesn't satisfies all these other requirements of relative group disadvantage and isn't protected, you're protected. So that may be one way. British law does not allow that. It requires Parliament to, it's much more skeptical of courts, Parliament has to legislate. Group disadvantage takes many forms, and I think any decent regime of discrimination law has to have a very holistic understanding of what counts as discrimination in all its dimensions, in political, material, economic, socio-cultural dimensions, and different groups face disadvantage in different ways. and that groups have interests other than the anti-discrimination interest of their members, as you quite rightly highlight. I'm not sure I've answered your question, but those are my random thoughts in response to yours.
Any final thoughts? Yes, Professor Baba.
Could I ask you to explain the image on the cover of your book, its relevance to the subject?
Yes. So this is a sculpture called Alison Lapper Pregnant. It's an image of a disabled pregnant woman. So Trafalgar Square in London has 4 plinths, and when it was being built, they put statues, of kings and horses and stuff on 3 of the pillars and ran out of money. So the 4th plinth was empty, and at some point the city decided to make it a space for public art, and it commissions art projects every once in a while and puts on public display. And this was on display for around 2005 and 6, around that time. And I just liked this image, well, for aesthetic reasons, because I thought it challenged our notions of what is beautiful and artistic, but also, one of the themes in the book is intersectionality, and I thought, it captured gender, pregnancy, and disability in very interesting ways. But also, it's a very proud image, as in you don't see her and think of her as a victim. It's partly the scale of the statue, and even her disability needs some closer attention. It's not entirely obvious because you have all these classical marble statues whose arms have fallen off over time, and it's easy to mistake that until you notice that this is quite a contemporary statue. So it was just a combination of all of those factors, which I found quite attractive.
On this cultural note, please join me in thanking Professor Khaitan for what was really